SV University, student studying 5-year LLB. It is my immense pleasure to welcome you all for the today's webinar on Introduction to International Law. It is my privilege to welcome you to the today's webinar, and it's my privilege to welcome today's eminent speaker and chief guest, Ms. Sirine Ghorbal Garu. I also welcome the participants, students of SV University, students from various colleges. We are proud to announce that this webinar is being conducted by the 5-year Law Department of SV University with the cooperation of SV University, and this is the first ever international webinar in the history of our university. As our today's eminent speaker and chief guest of the today's webinar is from Tunisia, I wish to express few lines regarding India, its greatness, and about Indian law as well. Our India is not a nation nor a country. It is a subcontinent of nationalities. India is well known for the slogan Unity in Diversity around the globe. India is one of the youngest superpowers in the world. India is a land which harvested happiness, a touch of light in the lives of blackness. Behold that wonder which is not left to the fate. My great India is greatness ever so great. Coming to the topic of Indian law, our Indian legal system is inherited from the legal system introduced by the British during their colonial rule in India. Our primary sources of law are customs, legislature, ordinances. Secondary sources are common law, law of merchants, and case laws. Judiciary is the third very important organ of Indian government. Judiciary is the guardian of the human rights, protector of constitution, and promoter of peace and cordiality in India. It check and balance the legislative or executive actions of the government. India being the world's largest democracy and multilingual federal state, the Constitution of India confer power to enact law on its parliament and legislatures of states, and our Indian Constitution is the longest written constitution of any independent nation in the world. It contains 22 parts, 395 articles and 12 schedules, and total of 1,17,369 words in its English language version. This is a compendious note on India and Indian law. Now I hand over to Kusuma, who will speak about our prestigious SV University. Kusuma, over to you.
You all. I'm very privileged to take part in Venkateshwara University, Tirupati.
I can't hear you. Sorry. I think that there
Good
is
evening,
the microphone, maybe.
Kusuma, something is problem from your microphone. Josh Nasri, you will continue with
Yes.
University.
I think some glitches are being projected. So I'll continue. Instead of Kusuma, I would like to share about my own SV University. So first of all, this webinar is wholly conducted by the prestigious SV University of Tirupati. Our university is established in 1954 to cater the educational needs and aspirations of the people of Rayalaseema region of Andhra Pradesh, India. It is the world famous holy temple town of Tirupati on the sprawling campus of 1,000 acres with a panoramic and pleasant view. The university has grown excellently from the strength to strength over past 66 years. It has gone through great strides in the transformation of the university with acquiring necessary and modern sophistications, instrumentation to catch up with the world competition in academic and research programs. Besides strengthening an existing curriculum, new courses are being planned under Miru program. This is all about our university. And now I would like to give over to Vasavi, who will No, I would like to give over to Jita Maitreyi, who will speak about our today's chief guest, Sirine Ghorbal Garu. Jita Maitreyi, over to you.
Thank you, Joshna. A very good morning to all of you, especially Madam. Thank you for attending our webinar, which we are requested to do. It's a pleasure to introduce Ms. Sirine Ghorbal Garu, a Tunisian who was born in 1995. She has done refugees law from International Institute for Human Rights from Strasbourg, France. Criminal psychologist diploma in the Center of Excellence, London, from International Law in Action, which was specialized in the investigation and prosecuting international crimes from Leiden University, as well as general English from Amidest Tunisine, and the Korean language from the Tunisian Korean Culture Association from Tunisia, and many more honorable degrees. She took academic training from the year 2014 from National Baccalaureate Diploma, hence Faculty of Legal, Political, as well as Social Sciences of Tunis from the year 2014 to 2018, and also the Research Master in International Law from 2018 to 2021. And then looking forward has the Faculty of Human and Social Sciences of Tunis from the year 2020, and she was also an PhD student in the international law from the 2022 to till date. So we are really glad to have you here, ma'am. Thank you.
Ma'am, our topic on today's webinar is Introduction to International Law. International law serves as a framework for the practice of stable and organized international relations. Our guest speaker is a PhD researcher in international law and an independent legal advisor. Now, without any further delay, let us begin the vital part of our today's program. Let us begin the webinar. I welcome Sirine Ghorbal Garu to have a talk on the Introduction to International Law. Ma'am, please.
Thank you. So you can see my screen? It's okay?
It's visible, ma'am.
Okay. So the theme of this webinar is Introduction to International Law. Therefore, I will focus mainly on determining the concept of international law, its characteristics, its sources, and the role of India in the development of international law. So, as I can unfortunately only stay with you for 30 minutes now.
Ma'am, small submission, ma'am. You are not visible properly, ma'am. Can you please check it once?
Can I use the camera and the screen at the same time?
Yeah, ma'am. No.
So let me just check.
Yes, now you are visible, ma'am. No problem now.
Okay now?
Yes, ma'am. Okay.
Okay, good. So I would like you to email me your questions by email after the webinar, since we don't have so many time now. So let's start by the introduction of. No, I think that I can't use the screen and camera at the same time. It's blocked. Yes. Okay. So let's start by the introduction, which contains 3 parts about what is international law, how has international developed, and public and private international law. So international law is an instrument of international public, a set of rules, discourses, and techniques that international subjects and actors use to regulate their relation and achieve certain social goals. International law is also a cultural and historical product, the fruit of a contrasting evolution over several centuries that has helped shape it as it appears today. It's a fundamental process for regulating and channeling international violence, an indispensable common language, an instrument technique at the service of states and all actors in international society, a promise of pacification. That's what international law. States are the main subjects of international law. At first, international law only regulated relations between independent states and mainly within diplomatic relations and war. Nowadays, there are more subjects of international law and its content has expanded as well. Problems of international law concern need collective state action, and modern technology has led to closer and more frequent contact between states and their peoples. So as a result, the contact needed to be regulated by new rules. Another expansion is that international law also deals with matter which traditionally was regarded as being within state domestic jurisdictions, like use of territory or treatment of inhabitants. This means individuals have international personality to some extent because they have certain rights. So international law has limited the sovereignty of states in favor of more recognition of human rights. How international law developed? Positivism influenced during the expansionist and industrial 19th century, when the notion of state sovereignty was buttressed by ideas of exclusive domestic jurisdiction and non-intervention in affairs of other states, ideas that has been spread throughout the world by the European imperial powers. In the 20th century, however, positivism dominance in international law was undetermined by the impact of two world wars. The resulting growth of international organizations, the League of Nations founded in 1919 and the United Nations founded in 1945, and the increasing importance of human rights. Having become geographically international through the colonial expansion of the European powers, international law became truly international in the 4 decades after the Second World War, when the colonization resulted in the establishment of scores of newly independent states. The varying political and economic interests and needs of these states, along with their diverse cultural background, infused the 30 European-dominated principles and practices of international law with new influence. So, development of international law, both its rules and its institutions, is inevitably shaped by international political events. From the end of the Second World War until the 1990s, most events that threatened international peace and security were connected to the Cold War between the Soviet Union and its allies and the United States-led Western Alliance. So the United Nations Security Council was unable to function as intended because resolutions proposed by one side were likely to be voted by other. The Bipolar of Alliances prompt the development of regional organizations. The Warsaw Pact organized by the Soviet Union and the North Atlantic Treaty Organization, the NATO, established by the United States and encouraged the proliferation of conflict on the peripheries of two blocs, including in Korea, Vietnam, and Berlin. Furthermore, the development of norms for protecting human rights proceeded unevenly, slowed by sharp ideological divisions. About public international law and private international law. So international public law is different from private international law, which is part of domestic law, and foreign relations law also, which is about the relation between a certain state and other states. Through the area of practice, the two types, public international law and private international law, are often considered as having the rule on a global level within developing the international community. So in order to function, international relations need a legal framework with identified norms, thus of public international law, also called law of nations. So this corpus consists of all the legal principles applying to the subjects of international societies, the states and international organizations. The key emphasis is on creating a broad scale and a basic minimum legal order. Private international law, or conflict of laws, on the other hand, is a framework that combines the various laws from different countries. It addresses the issue of the applicability of international or domestic law in the domestic courts. That means that it is the branch of legal that is complemented when two or more sets of legal structures clash over a particular topic. It is a collection of procedural rules which determine which legal system and jurisdiction shall apply to a particular dispute. During colonial rule, India consisted of several states with distinct cultural and beliefs, often due to which there was a dispute between British law and personal law in India, as various laws apply to citizens belonging to different beliefs. Until independence and even till state recognizing, India was a nation that had distinct legal structures between British India and native Indian princely states. In British India's judicial system, the judgment pronounced by the courts of princely states was considered as international judgments. During the British time, therefore, there was an interstate conflict of laws in India. Also during the British era, when the Indian merchants were trading outside India, there were cases of commercial litigation with an international dimension in before the Indian courts. Since India was a British colony, it followed narrowly British rules concerning private international law. Nevertheless, the irony of the situation is that the Indian legislation has struggled to pass sufficient legislation in the field of private international law, even after so many years of independence. So let's move to our first part related to nature and aspect of international law. One can question whether international law is actually law, but states have accepted it as such and refer to it in their constitutions. Most of the time, states act in accordance to international law as well. Some people say international law is not sufficient, or because it has failed to maintain international peace. They do not keep in mind that law cannot dictate the politics and behavior of states. Also, international law cannot prevent its violation, like criminal law cannot prevent crimes. International law is a means to handle a situation, like operators within the legal system that's the fault of law. International law is effective on a day-to-day level, but these are only small accomplishments. So international law has some characteristics. In principle, participants are equally sovereign states. It's not forced on states. It's not legislature, and it's not obligatory, but sanction can be used to influence an offending state. This sanction can be economic and diplomatic, but the public opinion is important as well. States also act according to international law because of the rule reciprocity. it is for our good. According to the second part, related to the sources of international law. So sources are important to express what the law is and where it can be found. However, there is no international legislature or international constitution. There are no law-giving sources, so no organs and no tasks are defined. So how can the lawless can be determined? Sources of international law can either be material or formal. The material sources are the content of the legal norm. They determine how a legal norm will be elaborated. Sociological, economic, psychological, and cultural factors lead to a decision that later will be formalized in other sources of international law. So the material sources refer to these decisions. The formal sources now are the methods and processes of creating legal norms. They are mentioned in Article 38 of the Statute of International Court of Justice. There are four main sources of international law as defined in Article 38.
Ma'am, you are not visible, ma'am. It's glitch of.
Oh, sorry.
Yes, now you are visible. I think it's some problem is there.
Oh,
Now you are, now it is okay, ma'am.
okay now?
Okay, no problem.
Okay. So I said that there are four main sources of international law as defined in Article 38, international conventions, called also treaties, international custom, general principles of law, and finally judicial decisions and the teachings of the most highly qualified publicists. State can also ask court to decide a case by using principles as fairness and equality instead of just using strict rules. Even through Article 38 is just a direction to the International Court of Justice. It is seen as an authoritative statement on the source of international law. That means that Article 38 doesn't have the objective of being exhaustive. In it, the sources of international law are just exemplified. Furthermore, the statute doesn't set a hierarchical level between the sources. That is, there is no degree between the sources of international law. But in practice, there is a rule for procedure. First, the treaty is applied. By absence of the treaty, the custom is applied. And if there is no custom, the general principles can be invoked. Judicial decisions and readings can determine the rules of international law, but they are not sources. Nowadays, international law is more specialized and divided into different fields called the fragmentation of international law. International law also release other more dynamic sources such as acts of international organizations and soft law. Let's start by international conventions. In general, international conventions or international treaties are the main source of international law. For the validation of a treaty, it is necessary the direct and democratic participation of the involved states. They are direct, clear, and easy validation source because it is necessary its written and ratified documentation by all states that compromise to adhere to its rules. Treaties can be bilateral, which means that they are between two states, or can be also multilateral, which means that they are between several states. There is also a distinction between lawmaking treaties that can only create particular law between the signatories and treaty contracts, which have many signatories and create law per se. Treaties create international law for the parties signing it. Multilateral treaties have a wider effect and can be seen as lawmaking because the provisions of the treaty can become customary international law. Multilateral treaties have a quasi-legislative effect. About the international customs, first, states simply did what they wanted to do, but when the contract between states increased, certain norms of behavior turn into rules of customary law. Custom becomes less important as the legal system matures. Its contribution is still reflected in many treaties. The international customs are generally practiced, accepted as a law. They are the second major formal source and historically the older. For the formation of the custom, two elements are required: the material, generalized repetition of certain acts, and the psychological, the fiction that such acts are practiced by obligation. The customs must be proved so that they are valid. That's about international custom. Let's move to general principles of law. So the general principles of law are sources hard of identifying, and many have already been agreed to in treaties or are already considered as customs. The principles are norms that derive from national law or domestic law and are accepted in the international law. We can consider, for example, the principles of good faith, protection of trust, and equal rights as a general principle of law. So besides the main sources, the international law also has sources, judiciary decisions, and publicity doctrines. They are called new sources or auxiliary means. We can mention jurisprudence, interpretations made by the courts that end by determining a norm. They are considered as auxiliary means because new norms can't be created by them. They only register the interpretation of the law. Also, writers help determine and articulate the content and principles of international law. Or writers can provide interpretations of law and identify areas where international regulation should be encouraged. Writings are not a source of law, but a means of determining what the law is on a given subject. Since they are skilled for such, their interpretations can also be considered auxiliary, mean just as the jurisprudence. We can also set the analogy and equity come into play as auxiliary means in case of lack of legal norm for a certain case. It has the objective of coming up with the fairest decision on conflict of interest. The analogy is the application of a legal norm made to serve another similar case, while the equity takes place when there is no legal norm capable of reaching the particular case. Or also jurisprudence, a set of norms that overlap the autonomy of state willingness. they are hierarchical, superior to the conventional norms, and can't be repealed by treaties or customs. Among them are the prohibition of aggression, genocide, and slavery. That's all about our second part, the source of international law. So let's move to our third part, India and international law. So India has been a torchbearer in enhancing the ideals of international law. It has made a persistent effort to, among other things, promote a democratic multilateral legal framework, eliminate global economic inequality, enhance true democratic values and human rights, protect the environment, and achieve sustained development. The Indian constitution and international law have links dating back to the pre-independence day when India was a separate member of the League of Nations, even during the time of British rule. So the Indian constitution was greatly influenced by the values embedded in the Universal Declaration of Human Rights, which is an international document adopted by the United Nations General Assembly. So the fundamental rights in Part 3 of the Constitution and the directive principles. I think that there is another microphone.
No, ma'am, you can continue, please.
Okay. So I said that the fundamental part 3 of the Constitution and the directive principles of state policy in part 4 of the Constitution can be compared with the Universal Declaration of Human Rights, and many common points can be seen. Further, it can be seen that the International Covenant on Civil and Political Rights is reflected in Part 3 of the Constitution, whereas the United Nations Economic and Social Council is reflected in Part 4 also, and the preamble to the Constitution thus greatly benefits the scope of human rights law in India. Fundamental duties also, Article 51A of the Constitution of India gives force to Article 29 first of the Universal Declaration of Human Rights, which mentions the duties of the citizens toward the state, which help to build the nation and understand the importance of individual responsibility. So India is a part to more than 160 treaties and conventions dealing with various fields of law like air law, space law, and maritime law. The government is responsible also for implementation of the international treaties, what is a very good thing, and agreements to which India is a party. The Legal and Treaties Division was established in the Ministry of External Affairs since 1957 as a nodal point to deal with all aspects of international law advice to the governments of India. It advises the Ministry of External Affairs, in particular the Ministry of Departments and issues pertaining to international law and treaty, including treaty negotiations, practice, and interpretations. Also, the Indian judiciary does not have the power to make laws. It interprets the obligation of India in international law by adjudicating domestic cases concerning issues of international law. In this respect, The Indian judiciary has played a very active role in the implementation of India's international obligations under international treaties, especially in the area of environment law and human rights. So, as a conclusion, we can say that international law has, in the other side, been part of profoundly unequal international society since its modern emergence, where it fuels as much violence as it helps to calm. Thus, from being a simple neutral legal technique, it is and always has been the projection at the international level of the values and interests of the dominant actors in international society, while at the same time being used by movements of resistance to this dominant order. In this respect, it is intrinsically ambivalent. It is both an instrument of domination and an instrument of emancipation of the subjects and actors who use it. It is as much a weapon of the powerful as it is a bulwark for the weak. Also, the main weakness of international law is that there is no police or army to enforce compliance in the law. States can ignore principles and treaties. The value of compliance in international law is rooted in national self-interest. Also, if one state breaks the rules, another state may do the same. I hope that it was so brief and so clear.
Yes, ma'am, it's so brief and
Thank
clear.
you for your attention. So if you have any question, because we don't have so much time, please send me an email. So you can see my contact here.
Yes, ma'am. Thank you so much, ma'am. It is
Thank you
really,
so much.
Ma'am,
yeah,
it's been a wonderful lecture and you're a terrific speaker.
Thank you.
Thank you so much, ma'am. I extend my heartfelt gratitude towards you.
Thank you.
we're in different countries. We have different mindset, but today we are in one place, ma'am. It is virtually, but ma'am, we are waiting for in very last few months. Today it is fulfilled. So happy, ma'am. We are hope we meet physically and soon, ma'am. Whenever you visit to India, please plan once.
So
uh, it has a tremendous session today. We have so many followers also, ma'am. Here, our in our college,
thank you.
they actually some of members, I mean participants, not joined because we have an sports session also today. So few participants not joined. They are very big fans of you.
I
They
hope so.
really miss. But we are recorded it. We are definitely posted in YouTube, ma'am. Then they are happy.
Thank you.
Thank you so much, ma'am. It is a
Thank you.
formal vote of thank is there, ma'am. Joshna, can you please?
Ma'am, we would like to deliver vote of thanks. Now over to Vasavi, who will deliver the vote of thanks.
A very good evening to all. It's give me a pleasure to deliver the vote of thanks for the webinar to all the dignitaries assembled here. It's great honor and a privilege to propose a vote of thanks on this memorable occasion. First and foremost, I like to thank the Almighty God for making today's occasion resounding successful. For my heart fills with a lot of gratitude and respect for the distinguishing guest speaker, Man Sirine Ghorbal Garu. Is a PhD researcher in international law and an independent legal advisor for sharing their invaluable time for us to make grace the occasion, but also for the enlightening us with their commandant's talk on the subject. Thank you all for the clearing and our concept and enhancing over the understanding pertaining You have intended put best of your efforts to make this event unforgettable. I'm running short of words to express my humble thanks to the host for doing this event for us. You have provided us with the valuable support and enriching the webinar. Last but not the least, I thank you, my friends, for your cooperation in making this webinar a resounding successful. Finally, I leave this an inspiring quote by him. A woman and as a lawyer, we must never again shy from from rising our voice against sexual harassment. This is inspired Koti by Hilary Danny Silton. Once again, I thank you all for your attention. Thank you.
And once
Thank you so
again,
much,
I
ma'am.
extend huge gratitude towards you, ma'am. And thank you to each and every participant by joining this webinar and making this a huge success. Thank you so much. Jai Hind.
Thank you so much, ma'am, for sharing your knowledge with us and making us educated for a long time. And thank you for spending your most valuable time for us. Thanking you, ma'am.
Thank you.
Namaskar, ma'am. Thank you so much.
Thank you so
Hope
much.
it not stops from here, ma'am. Donate more in future.
I hope so.
Thank you so much, ma'am. Thank you so much.
Thank you so much.
Thank you.